Today marks the first time in this lecture series where Tan Sri Visu Sinadurai is no longer with us. Out of his profound respect and admiration for His Royal Highness Sultan Azlan Shah, Tan Sri Visu's stewardship of the series over the last 3 decades has laid the foundation for an enduring legacy in honor of His Royal Highness. Ladies and gentlemen, this afternoon, we are again most privileged to have another tourist deliver the lecture. To introduce today's speaker, I now invite the Dean of the Faculty of Law from the University of Malaya. Dean.
Your Royal Highnesses, ladies and gentlemen, distinguished guests, colleagues, and friends, Salam Sejahtera and good afternoon. Sir Christopher Greenwood Casey is a figure who needs little introduction in any gathering of international lawyers. A former judge of the International Court of Justice, a leading scholar, and one of the most respected advocates of his generation. He has helped shape the development of international law in profound ways. Born in 1955, he was educated at Rayburn Park School in Singapore, Wellingborough School, and Magdalen College, Cambridge, where he obtained degrees in law and international law. He taught international law at the University of Cambridge for nearly 20 years, before being appointed to the chair of international law at the London School of Economics in 1996. Sir Christopher today is Master of Magdalen College, Cambridge, a judge of the Iran-United States Claims Tribunal, and an international arbitrator. Sir Chris, for me today is meaningful in a personal way. In 1990, I studied law at Cambridge. Sir Chris studied law of peace and law of war. At a time when Sir Christopher was teaching there. So welcoming him now, here in this room, feels a little like welcoming a former professor back into the classroom. Except that the classroom has moved rather far south, and in place of an old, ancient, dusty blackboard, which I'm sure Sir Chris will recollect vividly, we now have a rather impressive LED screen behind us. This afternoon, Sir Christopher will speak on a question that is at once disarmingly simple and yet profoundly difficult. And in brief, it is, does international law matter in times of war? Few are better placed than Sir Christopher to reflect on this. Interestingly, he had previously turned the question facing us today on his head. Not whether international law matters in war, but whether a legal definition of war even mattered to international law when it comes to protecting the vulnerable. He reasoned in an article published in the International and Comparative Law Portal that it is more important that the rules of international law associated with war continue to apply in situations of hostilities, regardless of how war might be legally defined. The ends of justice are more important, more fundamental than the means. issues are not academic. For us Malaysians, the stability and predictability promised by international law matter deeply to our sense of security, our diplomacy, and our well-being. Sir Christopher, we're very honored to have you with us. And if any of my students were to begin their essays with, as Sir Christopher Greenwood said during his visit, I promise the lecturers will chuckle a little before deducting marks for overexcitement. Ladies and gentlemen, please join me in welcoming Sir Christopher Greenwood. Thank you.
Royal Highnesses, Your Excellencies, Chief Justice, distinguished guests, ladies and gentlemen. It is the greatest possible honour to be invited to come here and give the 35th Sultan Azlan Shah lecture this year. As we have heard in the remarks made earlier, Sultan Azlan Shah's contribution to the common law and to public service in Malaysia, as a jurist, as a judge, as a monarch, and as a statesman, are something which deserve very much to be remembered and honoured, and I am delighted to play a part in that. Honoured, but I have to say, sir, a little daunted as well, as I looked at the faces of previous Azlan Shah lectures as they went up on the screen. I lost count of how many law lords, Supreme Court judges, and Lords Chief Justice have given this lecture before me. And as one of them said, this is one of the most prestigious lecture series of the common law world. So it is perhaps a little dangerous for me to have taken as my title today a subject of international law. Common lawyers are not always friendly towards international law. Not that long ago, in the international tin litigation in which I was involved as counsel, one British High Court judge remarked, "Ah yes, I know about international law. English law is law, foreign law is fact, international law is fiction." Well, I'm going even further, because I'm not just talking about international law, I'm talking about the international law of war. And war is always thought to be the very antithesis of law, the one activity of humanity that cannot admit of any sort of legal regulation. And yet, is it so far removed from the practical world of the common lawyer? I would like to suggest that it isn't, and indeed, I was struck in doing the research for this lecture that in 3 of the first cases that Mr. Justice Raja Azlan Shah, as he then was, sat as a judge in the federal court, he was actually grappling with questions about the laws of war in relation to the confrontation between Malaysia and Indonesia. So this afternoon, what I will try to show is that international law does regulate war. And secondly, that in doing so, it can make a difference, and a difference for good, a difference that is beneficial. And lastly, that what it does is not at all remote, in reality, from the common sense world of the common law that we all know and love so well. But first, let me just say a brief word about international law. Any law reflects the society in which it operates, and international society is arguably the most bizarre creation you could possibly imagine. It is completely different from any form of national society. There is no legislature, no executive, and although there are courts, they are not courts that have a compulsory jurisdiction. The International Court of Justice, of which I was a member for 9 years, can hear a case between states only, I should say also it only hears cases between states, although the day I took office as a judge, I heard the telephone receptionist patiently explaining to somebody that they could not put him through to the President of the Court to discuss why his divorce was taking so long. The International Court has jurisdiction over a case between states only if both of those states have at some point become party to a treaty accepting the jurisdiction of the court. That, incidentally, is the reason why so much of the litigation taking place at the moment relating to issues of war is brought under the Genocide Convention, because the Genocide Convention is unique amongst the treaties regulating warfare in having a clause providing for the jurisdiction of the International Court of Justice. I have to say that that is an exceedingly mixed blessing. It means that on most occasions, it is extremely difficult to prove the necessary intention for a crime of genocide. Genocide consists not merely of killing large numbers of people, but of doing so with the intention of destroying an ethnic, racial, or religious or national group in whole or in part. And in one case under the Genocide Convention, in which I was involved as a judge, it was plain that although war crimes had been committed, crimes against humanity had been committed, some appalling atrocities had taken place, there was no chance whatsoever that the claimant state was going to succeed in proving the necessary intention of genocide. And there is a further difficulty, and that is that by bringing cases under the Genocide Convention, you automatically increase the level of political tension. No state is going to accept that it can properly be accused of committing genocide. So the institutions of international law are weak, the society is decentralized, and the result of all that is that you have a society in which a lack of equality is far greater than it is in any nation state. The disparity in wealth, population, territory, military power between the big states and the small ones is enormous. You have only to compare the military might that can be deployed by the United States, for example, with the complete absence of armed forces in something like a quarter of the members of the United Nations. China and India, each with populations of about 1.5 billion people, sit in the General Assembly of the United Nations alongside ours with a population of 10,000 and have the same voting power in the General Assembly. China, of course, has a veto in the Security Council. So the society in which international law operates is one that is not particularly conducive to the rule of law. Now, how then is that law made? It comes about because of what states do, not because of what professors say. And the two main sources, the only two with which we need to be concerned today, are treaties, agreements between states, the participation in which is voluntary. No state is required to become a party to a treaty if it chooses not to do so. And secondly, what is called customary international law, which be familiar, I think, to the common law. It's based on the practice, what states do over a period of time, and whether they have, in doing that, a sense that they are obliged to act in a particular way, or they are asserting the right to act in a particular way. And just as Oliver Wendell Holmes said of common law, that the life of the law has been not logic, but experience, so the International Court of Justice, in a maritime dispute between Libya and Malta, made clear that international law is based upon the actual conduct of states, and not upon some abstract statement of principles. And that can sometimes create difficulties for a national court when it is confronted with an issue of international law. In most common law countries, the United States being a partial exception, a treaty is not part of the domestic law of that state. It can only be enforced by a national court if the Parliament of that country incorporates the treaty or gives the courts the power to give effect to it. Customary international law, on the other hand, despite the comment by the judge in the International Tin Council, is something with which national courts have to deal on a very regular basis. And as we will see, both treaties and custom came to bear in the confrontation cases. Let me turn then to the first of my questions. Is there any law on warfare? War is as old as mankind itself. And if one looks at the past, it was clear that for centuries we operated on the basis not of the rule of law, but rather on the principle that might is right, that the effect of defeat in battle was brutality, slavery, death. The book of Deuteronomy in the Old Testament talks about with some pride about how the Israelites destroyed other nations, burned their cities, killed their men, women and children, keeping only their cattle as the spoils of war. It really was a world where to the victor went the spoils, to the defeated, death or slavery. And for that reason, Cicero, the great Roman lawyer, once said, "Inter armes silet leges," amidst the clash of arms, laws are silent. And yet, there are human values that shine through in spite of all that, and that gradually led to the development of customs and later of treaties designed to preserve some element of humanity, even in warfare. You find that in Islamic, in Christian, in Hindu traditions, and doubtless of those of many other religions. And in modern law, it began to evolve in the late 17th, early 18th century. First of all, and no lawyer would be surprised about this, for the protection of property, being by far and away the most important thing for any lawyer in those days. And in particular, property at sea, with the development of very complicated rules about when shipping could be seized, when cargoes carried in neutral ships were contraband and could be taken. And there was a system of prize courts which grew up in all the leading maritime powers to determine questions of this kind, and which applied international law to obtain the answer to these questions. But then gradually it became more important than that. There evolved a law for the protection of wounded in battle who could no longer take part in the fight, of prisoners, of civilians, and in particular of women and children. And those developments reached perhaps a high point at the end of the Second World War, with the adoption of the 4 Geneva Conventions on wounded on land, on sea, prisoners of war, and civilians, designed to preserve a basic humanity, even amidst the clash of arms. Now, every nation in the UN is a party to the Geneva Conventions. In the case of Malaysia, it became a party in 1962, a very important development given the start of confrontation the following year. That means that the Geneva Conventions, at least, provide us with a universally agreed set of rules and principles. There are later developments, other conventions, to which many states have chosen not to become a party. But I want to focus mainly on the key points in the Geneva Conventions. Taken together, they run to about 250 pages. And you may be pleased to know I'm not going to try and offer you a summary of them this evening. I just want to look at one or two of the central principles. But before I do so, I should mention something else. And that is, after the Second World War, the Charter of the United Nations also sought to address a much more fundamental question, which is when it was legitimate for states to go to war at all. And basically confined the use of force, the legal use of force, to self-defense of this state or of others, and possibly, although this is far more controversial, in extreme cases of humanitarian intervention. Let me stress, all of this is not an abstract concept imposed from on high, but something that states have chosen to accept, and that all states have chosen to live their lives by. There are, I would suggest, a number of core principles to those conventions. The first is a recognition of the fact that war is about defeating your enemy, either by bringing them to the negotiating table or destroying them utterly, and that therefore violence is an integral part of war. There is no point in pretending otherwise. Instead, what the law seeks to do is to prohibit unnecessary violence. So the use of force against civilians is prohibited because civilians are not themselves part of the war. They are not going to contribute to your enemy's war-making machinery, unless, of course, they work in something like a munitions factory, when that factory will be a legitimate target. Prisoners should be humanely treated because they are out of the battle. They are not going to take a part in the fighting that follows. And there is a general principle prohibiting the infliction of unnecessary suffering. Now, none of this is in conflict with the basic purpose of war. On the contrary, it could be said to reinforce good military behaviour. If Prince Rupert of the Rhine's cavalry in the English Civil War had spent more time fighting parliamentary cavalry and less time looting the baggage trains behind the scenes, Charles I might well have ended up with his seat on the throne rather than his head in a chopping block. It's not the case that observing the law is something which distracts from the basic military principle of winning war. The ill-treatment of civilians in occupied territory is usually the antithesis of what is needed for success. In the Second World War, there were numerous examples of civilian populations who welcomed an invader when the invader first arrived, only to become extremely disillusioned and rebellious within a few months after the oppressive regime was forced upon them. So that is a brief sketch of international law on this subject. The critical question is, does it make any difference? Does it do any good? Now, many people have suggested it not. Tolstoy in War and Peace, as Prince Andrew or Prince Andrei prefer, say that it would be better if there were no rules about human treatment of prisoners. It would be better if war was seen for what it should be, ultimate violence and destruction. And then the states and people would be less willing to resort to it. Admiral Lord Fisher, the first Sea Lord in the British government, put it rather more firmly that he chose his moment wisely. He chose the first Hague Peace Conference to say, if you rub it in, both at home and abroad, that you will kick your enemy when he is down, boil your prisoners in oil if you take any, and torture his women and children, people will keep clear of you. Well, people tended to keep clear of Lord Fisher anyway, as Winston Churchill, who fell out with him badly in the First World War, will testify. But all experience, particularly the history of the 20th century, refutes the view that Tolstoy and Fisher put forward. There is no sign whatsoever that fear of the terrors of war, and heaven knows there are enough such terrors, has discouraged states and people from going to war. In 1939, states went to war again, notwithstanding the appalling carnage of the First World War only a quarter of a century ago. Nor does the kind of unrestrained savagery that Lord Fisher was suggesting work within a conflict. Savagery tends to beget nothing but savagery in return, reprisals, retaliation, and perhaps above all, a realization that surrender might not be the best option open to you if the fate that was going to befall you was the one that Lord Fisher suggested. In short, it doesn't work. But there is surely more than that, and that is that there are certain human values which we as peoples share. Part and parcel of the rule But it's also worth asking ourselves, if that is the way we want to conduct military operations, what sort of people are going to be coming home to us at the end of the conflict? Brutalised, frightened, often wounded, they are not likely to be the best citizens for a state based on democratic values. So international law can do some good in this context. The question is whether it actually does. And here there's a more fundamental difficulty, and that is the argument that most people don't actually take any notice of it. Or perhaps more seriously still, only the good guys take any notice. We observe the law, but others do not, and therefore we put ourselves at a disadvantage. Well, no one will pretend, and I'm certainly not going to, that international law in relation to war is invariably effective. It certainly isn't. One only has to look at the carnage going on in the world at the moment to realise that violations of the law are commonplace. But we wouldn't suggest that there is no point in having a law that prohibits murder, or burglary, or shoplifting, or drug trafficking, simply because all of those activities take place. We never expect 100% compliance with the law. If that was going to happen, I would be out of a job, and so I suggest to quite a lot of other people in this room. So, the fact that international law is not invariably successful is not a reason for disregarding it completely. On the contrary, there are some really quite wonderful examples of how international law has made a difference. I'll take one about prisoners of war. The Iran-Iraq War, which raged from 1981 through until the end of the 1980s, was one of the most savage of modern times. It involved a degree of casualties on both sides, comparable in terms of the percentage of the population to the casualties suffered in the First World War. And yet, the International Committee of the Red Cross registered something like 200,000 people as prisoners of war, inspected the camps in which they were held, enabled some correspondence between prisoners and their families. And since many of these soldiers who were captured were young teenagers at the time of their capture, and grew to adulthood in a prisoner of war camp, the ability to send and receive letters to and from their families must have been an enormously important consideration for them. Moreover, the Red Cross reports of that conflict suggest that your chances of survival increase dramatically once you appear on the Red Cross list of prisoners. Far too many people never made it to prisoner of war camps. Those who did generally survived. So that is an example of the law working in that area. You could take other examples. The treatment of civilians in occupied territory. All our history suggests that treating people well, ensuring that you wage a fight for hearts and minds, tends to make the governance of occupied territory very much easier and very much safer than brutalising and terrorising the population would ever do. I don't wish to suggest that compliance is easy. There are many areas in which it is exceedingly difficult. For example, the principle of proportionality dictates that even the military objective should not be attacked if the civilian casualties, the collateral casualties likely to be caused, are such that they will outweigh the military advantage to be obtained from that operation. And that calls for very fine judgments on the part of what are often young soldiers, very often conscripts. It calls for very complicated decisions by politicians, by generals. And those decisions can go wrong. But the fact that they can go wrong does not mean that they shouldn't be made. And it doesn't mean that they are not being made. Some of you may also ask, well, all very fine, but how do you enforce this law? Well, the short answer to that question is with the very greatest difficulty. There was a series of war crimes trials at the end of the Second World War, but then nothing until the creation of the Yugoslav War Crimes Tribunal in 1994. And even that was very slow getting going, although in the end it did succeed in getting custody of every defendant that had indicted and who was still alive. And it concluded most of its trials with perhaps the best testimonial that you can expect in these circumstances, namely that it was accused of bias like all the different parties in the armed conflict. That's probably the only test of impartiality that you can expect. But far more important, to my mind, than attempting to prosecute individuals is the other measures that can be taken to ensure compliance with international law. And over the years, as a lawyer, I advised different governments, I helped to write military manuals, and I saw the lengths to which so many governments went to try and ensure that their soldiers knew about the laws of war and complied with them. And that brings me to the confrontation cases. Now, confrontations, you will, I think, all know, took place between 1963 and 1965, between Indonesia on one side and Malaysia, Britain, Australia and New Zealand, and Brunei on the other. There was no declaration of war. Neither side treated it as a war in the formal sense, but that doesn't really matter, because the Geneva Conventions apply to any armed conflict between states, irrespective of whether war has been declared. And all of the states that were parties to confrontation had ratified the Geneva Conventions and given effect to them in their own domestic law. Now that was tested in two cases that came before the Federal Court and then in due course the Judicial Committee of the Privy Council. And they are etched on my mind because I was living in Singapore at the time, and I actually remember both of the incidents that gave rise to these cases. The first involved a drop by Indonesia of something like 100 paratroopers at Laos in northern Johor in the summer of 1964. Now, it has to be said, nobody would suggest that this operation was militarily successful. The saboteurs who were landed succeeded in doing virtually no damage whatsoever, and they were either killed or captured within a period of a few weeks. They were a mixture of people. Some were members of the irregular Indonesian armed forces, but there were also some 14 people of Chinese ethnicity, but who had either been born in Malaya or at least had grown up in Malaya. And most of these carried Malaysian ID cards, usually the blue ID card, which identified the holder as a national of Malaysia. Not quite true of all, but it's true of the majority. Now, they were all charged, these Chinese Malays, they were all charged under the Internal Security Act with two different offences: the unauthorised possession of firearms and explosives, and being associated with persons who had unauthorised possession of firearms and explosives. So the first charge related to what you actually had in your possession at the time of capture, or could reasonably be presumed to have had immediately prior to capture. But the second charge concerned their association with the Indonesian soldiers, and the Indonesians were not prosecuted. Now those cases, there were 12 separate cases. They came before the High Court here, where all the defendants were convicted and sentenced to death. They appealed to the Federal Court in a series of cases, and three of which, the State Father was one of the judges on the bench. Now, in the appeals, the Federal Court took rather different views with different compositions about precisely what was involved. But there are 2 points here. The first point is that under the Malaysian law, the Geneva Conventions Act, if there was doubt about whether somebody was entitled to be treated as a prisoner of war, the court was to be notified of that fact, and no trial was to proceed unless and until their status had been determined by a competent tribunal. The second question, which lies behind this, it is not as clearly articulated in the case as it might have been, is that if they were prisoners of war, then they weren't committing offences under the Internal Security Act. Because Indonesian military operating in Malaysia were not subject to the ordinary criminal law of Malaysia for ordinary acts of militarism, any more than Malaysian and British soldiers operating on the Indonesian side, or Borneo, were subject to Indonesian law. A soldier who fires at another soldier is not guilty of a criminal offence under domestic law. That was the principle that the court was stating around, and not always grappling with in these different appeals. Now, one bench of the Federal Court, presided over by the then President, Sir James Thompson, decided that a national of Malaysia, or anyone who owed allegiance to Malaysia, was not entitled to be a prisoner of war if they were captured, bearing arms and wearing the uniform of the enemy, the belligerent power of Indonesia, because they were guilty of treason, and they were therefore placed in a different position. And in coming to that conclusion, the Federal Court drew on a wide range of authorities, cases from different countries, but also the writings of Sir Bertrand, the greatest international lawyer of his day, whose book on the subject was firmly with the view that you were not a prisoner of war if you fought against your own state in the armed forces of your enemy. They then concluded that the fact of being born in Malaysia, or of long residence in Malaysia and possession of identity card, was sufficient to establish a duty of allegiance to Malaysia, and therefore to remove you from prisoner of war status. But only a few weeks later, a differently constituted Federal Court bench, presided over by the then Chief Justice Paduka, held that nationality alone was sufficient to take you outside entitlement to prisoner of war status, and that nationality had to be proved by the prosecution. In other words, it was for the prosecution to show that each of these captured individuals was a Malaysian national. Now, those cases then went to the Judicial Committee of the Privy Council in London. The Privy Council, I'm not sure I regard the Privy Council's decision as a masterpiece, but we'll come to that in a moment. The Privy Council took the view that the Thompson approach was correct, that anyone who was in possession of a Malaysian ID card owed allegiance to Malaysia. Anyone who was shown to have been born in Malaysia owed allegiance to Malaysia, whether they qualified as a Malaysian citizen or not, and therefore they were not entitled to prisoner of war status. So it dismissed the appeals by those who had been found to be Malaysians by the Thompson bench, and they upheld the appeal of the public prosecutor in respect of those who had been exonerated, if you like, by Chief Justice Paduka's bench. However, the Privy Council did spot the fundamental point in the case, which was that had they been prisoners of war, they would not have been committing the offence under the Internal Security Act. As a matter of international law, that must be right. And it shows how it's possible to apply the rules of war, to apply the relevant rules of international law, using common law techniques and interpreting the statutes in a way that is sensible and within the bounds of statutory interpretation under common law. And it's quite interesting that I looked up on the railing whether this case had ever been cited in any other case. And the only one I came across was a Scottish case a few years ago about trawl fishing just off the Scottish coast, which shows how this case was actually part and parcel of a broader common law tradition. The death sentences that were upheld by the Privy Council were not, I believe, ever carried out. Now, the second case is quite different. Muhammad Ali, the public prosecutor, is a case that took place in Singapore. In March 1965, in the last weeks of consultation, two Indonesians, almost certainly wearing civilian clothes at the time, because you wouldn't have walked down Orchard Road wearing Indonesian battle dress, and people would have noticed. Two Indonesians in civilian clothes planted a bomb in Darul House, which blew up a branch of the Hong Kong Shanghai Bank. Now, their target was probably the Australian High Commission, which was on the floor immediately above the back. But two of the man-tellers were killed, and the driver died of his injuries later. A few days after this, the two Indonesians in question were found clinging to some driftwood after their boat had capsized. They were dragged out of the sea, taken back to Singapore, and detained pending trial. At this point, the authorities made a fatal mistake. They let them mix with a number of Indonesian soldiers who were being detained, and they then acquired some Indonesian uniform and some Indonesian military ID cards. Now, these two people were Indonesians, there's no question about that. They were not in the same category as the defendants in the latter's case. But they carried out a serious act of war, and one which was undoubtedly illegal under international law. They had committed a war crime by blowing up a bank branch and killing the civilian staff who were killed in that. The case went to the federal court, interestingly enough, after Singapore had left the Federation of Malaysia, because it hadn't at that time separated judicially from the federal court. But the federal court sitting in Singapore upheld their convictions and determined that they were not entitled to prisoner of war status. But that federal court also spotted the core point, and that was that what they had done was not a legitimate act of war, in the same way that people at Labis were committing legitimate acts of war in uniform and fighting soldiers of the right of war. These were people who were gone disguised as civilians to destroy a civilian target. The appeal went to the Privy Council, and the Privy Council upheld their convictions. The Privy Council decided the case entirely on the point about uniform. These men were not wearing anything that distinguished them from the civilian population, either at the time they carried out the attack or at the time they were captured. In all fairness, at the time they were captured, they weren't really wearing anything at all because they were swimming for their lives. So that's perhaps not the Privy Council's strongest point. The death sentences were upheld. In this case, they were carried out some 3 years after the end of confrontation, causing, I'm afraid, a very considerable rupture in diplomatic relations between Indonesia and the United Kingdom. So Indonesia and Singapore. But what these two cases show is that a common law court, with no prior experience of dealing with issues of international law in relation to warfare, was perfectly capable of dealing with these problems when they came forward, and that they did so in a way that reflected all the values that Sultan Azlan Shah held dear, and which we saw highlighted on the screens at the beginning of this session: integrity, the rule of law, and impartial justice. All of those men received a fair hearing, and whether you think that the outcome was entirely desirable, I'll leave to you to decide. But it shows that common law courts are perfectly capable of dealing, as a practical matter, with the international laws of war. So where does that leave us by way of conclusion? I think it leaves us, first of all, with the conclusion that there is nothing abstract or academic about the international law of war. On the contrary, it's an intensely practical matter. The law is interpreted and applied by soldiers, by politicians, by courts on a regular basis. One of the cases that I was involved in as counsel, arising out of the Iraq conflict in 2003, raised a very difficult question of the customary laws of war about whether an occupying power was entitled to detain without trial somebody suspected of terrorist acts if they were a national of that state, but were found in the occupied territory rather than at home. And the Court of Appeal in that case produced a masterly judgment. Obviously, I would regard it as masterly because they found in my favour. But there are other reasons for thinking it was a good outcome. A masterly analysis of the customary law, which would do justice to any international court, and certainly to the International Court of Justice in the matter of this kind. So, courts are capable of applying it, and they do apply it. I've also seen politicians who've had to make decisions, often very difficult decisions, about whether it was lawful to attack a particular target, analyse that issue, then do it in detail, do it with care, and do it with common humanity. So although international law warfare is not universally effective, I think we can conclude that it can make a difference if states are prepared to treat with it in good faith. It will be effective if we allow it to be so. And to be frank, in conclusion, I would say that a world which turns its back on the law of war is a world without values. It's a world without humanity. And it is almost certainly a world without a future. Thank you very much.
Ladies and gentlemen, the Vice-Chancellor of the University of Mulia will now give the vote of thanks.
The Royal Highnesses, Sir Christopher Greenwood, distinguished guests, ladies and gentlemen. On behalf of University of Mulia, I extend our deepest gratitude to Sir Christopher Greenwood for a beautiful lecture that was as rigorous as it was profound. Sir Christopher's reflections traverse not just statutes and judgments, but the deeper architecture of justice itself. How law responds when humanity is tested by war, power, technology, and geopolitical fracture. As an engineer by training, I'm conditioned to see the world through structure, precision, stress points, and resilience. Yet today, Sir Christopher revealed to me a different kind of architecture, the invisible moral engineering of international law. I was struck by how legal principles, much like engineered systems, must be designed not just to function in ideal conditions, but also to endure failure, conflict, and human imperfection. The balance between legal rigidity and interpretative flexibility, between sovereignty and accountability, between power and restraint. These are not unlike the design dilemmas of any complex engineering system. And yet here, the consequence of failure is not material collapse, but human suffering. This realization alone reshaped how one understands the true gravity of the legal craft. Your speech and the theme of this lecture also reaffirmed for me that international law is not a luxury of peace. It is the last line of defense against chaos. In an age of autonomous weapons, cyber warfare, space militarization, and artificial intelligence, the role of international law is no longer peripheral, it is indispensable. This lecture reminds us that we should never take for granted the rule of law. It must be renewed by every generation, defended under every pressure, and upheld, especially even when it is political inconvenient. That perhaps, ladies and gentlemen, is the greatest lesson of the 35th Sultan Azlan Law Lecture. On behalf of University of Maya, I once again thank Sir Christopher Greenwood for his extraordinary lecture. Ampun Tuanku, thank you very much.
Your Royal Highnesses, distinguished guests, ladies and gentlemen, with the stimulating lecture delivered by Sir Christopher Greenwood, we come to the successful conclusion of the 35th Sultan Azlan Shah Law Lecture. May I invite you all to join their Royal Highnesses to the reception.
Amen.